In modern war, violence is often measured in casualties, in airstrikes, in numbers released at midnight briefings. But international law does not begin with bombs. It begins with words.
Well, the Genocide Convention has a specific provision saying that it is a crime to incite to genocide. And that obviously does raise question about freedom of expression. There has been only one case that has dealt with this issue specifically, and that is Rwanda.
From Lisbon, Frontlines and Backrooms podcast. Your host, Vladimir Bobatyk.
There are moments in history when speech becomes more than rhetoric, when repetition becomes pattern, when pattern becomes evidence. Under international law, intent is rarely confessed. It is inferred from actions, from policy, from words. In this episode of Frontlines and Backrooms, we examine how rhetoric shapes violence in Gaza, how institutions interpret intent, and how language becomes part of the legal record. Our guest is Professor John Quigley, scholar of international law and one of the most cited legal voices on genocide jurisprudence. This is The Crime Not Meant to be Hidden. Professor Quigley, welcome to Frontlines and Backrooms podcast, and thank you so much for your time to talk with us. Under international law, specifically the Genocide Convention and the Rome Statute, what constitutes direct and public incitement to genocide? How does it differ from protected, however hateful, political speech?
Well, the Genocide Convention has a specific provision saying that it is a crime to incite to genocide. And that obviously does raise a question about freedom of expression. There has been only one case that has dealt with this issue specifically, and that is Rwanda, where there was a radio station that broadcast instructions to people on where to find the Tutsis and suggesting that people go and kill them. This was a radio station called Radio Milcolin, and the individuals that were involved were prosecuted and convicted for incitement. So that's the only instance where it has been applied, and there it was applied because the speech was very specific in telling people to go and kill. And in criminal law, soliciting to murder is prosecutable. So this is not beyond what is customary in criminal law. Now, if you were just saying negative things about a certain population group, I think that would not constitute incitement to genocide. But exactly where the legal line is drawn is not clear.
If I understood correctly, a core element is actually intent. For a prosecutor or a legal scholar, what kind of public statements by political and military officials become evidence of the specific dolus specialis, the intent to destroy a group? Is it about patterns, specific wording, or the linkage to actions on the ground?
Well, it can be general. In the instance of Gaza, you have statements from officials saying we are going to deprive them of electricity and food and such. That kind of speech is relevant to show the intent of the government, even if it does not constitute incitement to genocide.
In legal terms, how do courts distinguish between rhetoric that is morally shocking and rhetoric that is legally probative? Where does the evidentiary threshold actually sit?
Well, if we're talking about speech by government leaders, that I think that is relevant to show intent. But exactly where the line is between rhetoric and general negative speech about the Palestinians in Gaza, um, it's not at all clear. I mean, hopefully there will be some clarity from the case that is now before the International Court of Justice, but that case will take another year probably before it is decided. But the government of South Africa is using the statements about depriving the population of the means of existence, and that clearly is relevant, because under the Genocide Convention, it is genocide if you inflict conditions that are calculated to bring about the physical destruction of a population. So if government leaders are saying we are planning to deprive them of medical care, of food, of fuel, that would certainly be relevant.
When a high-ranking minister of Israeli government or a senior military official make statements referencing historical amnesia, population transfer, or dehumanizing language about human animals, what is the legal weight of that? How does it potentially filter down through the chain of command regarding responsibility?
Well, I don't think the court can make a good judgment about that. I think it would simply use those statements and draw the conclusion that this is the intent that motivates what is being done. But what you're saying is also important because it does appear in the Gaza situation that those statements did filter down, and there are some video recordings that have been made that show soldiers at the ground level that are repeating those kinds of statements. And the court may look at that as well as evidence that the statements were more than simply rhetoric, that those statements were acted upon by the military personnel.
Does international criminal law recognize rhetoric as a part of the infrastructure of crimes, not just as speech, but as something that conditions, let's say, public behavior, policy choices, and how the military conduct on the ground? In this specific situation, if you have Israeli Minister of Defense says that in Gaza are human animals, is that type of the rhetoric or sentiment going to influence the actions of the military on the ground?
Well, I think the court would likely assume that it does, even if there is not strong evidence that the soldiers on the ground were specifically following that advice.
At what point does repetition matter more than escalation? Can banal, repeated language rather than overtly extreme speech carry greater legal weight over time?
I think that would be relevant if the talk is repeated. That is additional indication that this is the intent of the government. There was actually an instance in the Bosnia litigation where one side, I think it was the Bosnian side, was saying that military officials on the Serbian side had made statements rather similar to what one has seen from the Israeli leaders. And the court dismissed it and said, well, this is the kind of thing that you hear in wartime. Um, uh, so they didn't take it as evidence of genocide. But if you have it repeated, uh, then you're in quite a different situation. You can't just say, well, it's an offhand comment by a general. I mean, you could look to statements, I think, made by American officials against the Japanese during the Second World War. And they were very demeaning of the Japanese people in general. But, maybe those, I don't want to speculate, but uh, those probably were not sufficient to be evidence of genocide without something more.
Professor, this episode is titled The Crime Not Meant to Be Hidden. From a legal perspective, does the very public nature of some of the rhetoric we have heard amplify its severity or change its legal character?
It does. The specific language needs to be focused on, but only as part of a bigger picture. And I think that will be the approach of the International Court of Justice. South Africa is citing all these statements, but it is not relying on those statements alone. It will also be focusing on the evacuation orders that were given beginning in October of 2023 and the impact of those orders in the situation where the population had nowhere to go where they could sustain themselves. And the court will be looking at as well at deaths that resulted from the evacuation orders and the circumstances into which the population was forced to live. So one cannot isolate these statements. One needs to look at them as part of the bigger picture. To put it another way, if the Israeli officials had made those statements in the initial weeks after the beginning of the operation in Gaza, but then had said, oh, we're going to stop. Let's suppose they had stopped very quickly. Then I think those statements would not be indicative. But of course, there was no stoppage.
The ICJ, in case of Israel, applied plausibility standard rather than a finding of fact. From a legal standpoint, why is rhetoric particularly powerful at this preliminary stage?
Well, at the preliminary stage, the court simply needed to make a finding of plausibility that genocide was being committed. It did not need to make a definitive determination. That's because South Africa was asking for an injunctive order. And for purposes of an injunctive order, the court only needs to say that the allegations are plausible. So the court will not go beyond that. It doesn't need to go beyond that. And at the early stage, it doesn't have all the evidence to make a definitive determination. So the fact that the court said only that the allegations are plausible is not an indication that the court does not think that genocide was being committed. It's the procedures that motivate the court to limit itself to the issue of plausibility.
The ICJ found the risk of genocide in Gaza to be plausible. To what degree did the public record of inflammatory rhetoric by officials factor into the unprecedented provisional measure order? How does such rhetoric feed the court's assessment of the intent and risk?
Well, South Africa did recount these statements to the court, and the court mentioned them. So it does seem that the court took them into account in coming to the conclusion that it was plausible that genocide was being committed.
Professor, is there a point where the law effectively says, after this threshold of public language, deniability collapses, regardless of later clarification or disclaimers? I ask you this because a common defense is that such statements are metaphorical, are taken out of context, or the views of a few fringe figures.
Yes, I think it could still be genocide because the Genocide Convention becomes operative at a rather early stage in a situation. The Genocide Convention does not require that there be large-scale deaths of population. The purpose of the Genocide Convention is to prevent large-scale deaths. So the drafters of the convention specifically wrote the convention to apply at an early stage. That is, when a person or a state begins to take action that looks as if it might lead to large-scale killing, but where that has not yet occurred. As a result, there is a very strong case, I think, for there to have been genocide committed. Certainly by the time South Africa filed its case in December of 2023. So even if hypothetically Israel had stopped everything in 2024, there would still be a case for genocide. And now the fact that in 2024 the killing was quite significant, that certainly is relevant. But technically, I think even had that not occurred, you could say that genocide was committed by the time South Africa filed its case.
Even if the high bar of genocidal incitement is not met, can such public rhetoric constitute evidence for other international crimes, such as a prosecution, incitement to discrimination, or aiding and abetting war crimes by creating a permissive environment?
Yes, I think those statements are relevant on the other charges that could be made by the International Criminal Court. They could be relevant to the crime that you mentioned, persecution, which is prosecutable under Article 7 of the statute of the International Court of Justice. Or they could be relevant to violations of the laws of war, which require a state to refrain from action that affects the population in a way that is out of proportion to its military action. So if you have leaders referring to the population, people in negative terms, that would be relevant.
Beyond the ICJ's case, which looks at the state responsibility, What are the practical legal pathways for holding individuals accountable for alleged incitement? How do jurisdictions of the International Criminal Court, universal jurisdiction in domestic courts, or even internal legal mechanism interact here?
There are these different possibilities for prosecution. And the ICC is one of those possibilities, and you do have arrest warrants now that are outstanding against the two Israeli officials. In addition, as your question suggests, there is also the possibility of invoking what is referred to as universal jurisdiction in domestic courts. So that's something quite different. But I think often people are confused because when they hear the term universal jurisdiction, they think, wow, that relates to the International Criminal Court. But it does not. It's a different concept. And the concept is that any state that gains custody of someone who has committed internationally defined acts as crimes, that any state has jurisdiction to prosecute. And that's why it's called universal, because it means any state in the world could do that.
As a scholar of both law and history, do you see parallels in how public rhetoric has been used as evidence in past tribunals from Nuremberg, Rwanda to ICTY in case of ex-Yugoslavia? Are there lessons or precedents from those cases that are directly applicable today?
Well, in Rwanda, you had prosecution for incitement, but those statements did not come from the people who were actually carrying out the genocide. They didn't come from the government. So that's a bit different from the situation with Israel in Gaza. And in Bosnia, there wasn't so much evidence of those kinds of statements. As I mentioned, there was some, but it was certainly not at the level that we saw in Gaza. So the International Court of Justice doesn't have any precedents that it can look to on this.
This isn't just about accountability after the fact. The Genocide Convention imposed a duty on all states to prevent genocide. In your view, what is the legal obligation of third-party state when they are faced with a sustained public record of inflammatory rhetoric from officials of another state?
Yeah, this is a very difficult question because, as you say, the Genocide Convention imposes an obligation to prevent and punish. But it does not specify the circumstances. It does not specifically say that you have to prevent it if it is occurring somewhere outside your own territory. If one looks at the text of the Genocide Convention, one could say that that obligation to prevent applies only in a state's territory. However, the International Court of Justice has rejected that interpretation and has said, this was in the Bosnia litigation, it has said that that applies even outside one's own territory. But as a practical matter, what does that mean? So if it appears that acts are being done by Israel in Gaza that may constitute genocide. What is the obligation of Guinea-Bissau or so some other country in the world that is party to the Genocide Convention? Is Guinea-Bissau under an obligation to bomb Tel Aviv? Probably not. Um, so there's no specificity on this, and there has been no precedent that can tell you exactly what that means. It does probably mean that states are under an obligation to do what it is within their capacity to do. So the provision of armaments to Israel while it is engaging in genocide would probably fall within the Genocide Convention as a violation of the obligation to prevent. And this issue has been raised, of course, by Nicaragua in a separate case in the International Court of Justice against Germany.
Professor, genocide is considered as crime of all crimes. So it is difficult for prosecutors to make a strong case that some crimes were actually a genocide. Can you walk us through the process? What kind of evidence prosecutors need to prove the crime, and is the intent enough, or do they need to have more?
Well, you need to have acts and you need to have intent that accompanies those acts. But the Genocide Convention, as I say, was written to prevent acts that have yet to result in large-scale deaths. In particular, Article 2, subparagraph C of the Genocide Convention prohibits the infliction of conditions that are calculated to result in the deaths of a population group. So this comes into play at a rather early stage and is applicable if the state that is inflicting those conditions has reason to know that they will result in deaths within the population. So that actually makes it easier than one might think to make out a case of genocide. In Gaza in October, November of 2023, when you had the government issuing these orders for people to move from place to place, carrying only what they could carry, and moving them into places where there was no provision for sustenance of life, you have a rather strong case that genocide is being committed because the government of Israel would be doing that with the knowledge that this is going to result in deaths. You're removing people, let's say people who have medical conditions and need medications or need to be under the care of a doctor. When you remove people from that kind of a situation, you know that a certain number of people are going to die as a result. Someone who has diabetes, for example. So ordinary medical conditions. So even without any killing, even without military strikes, you know that there will be a consequence of death.
You might notice that the word genocide is used very often in the last couple of decades, almost to describe any bigger war crime. If we are using the word genocide too much or inappropriate, will that term will lose its significance, and will we deprive that term of its meaningful and rightful usage?
Well, I think there is that concern. Uh, People do tend to use the term genocide rather broadly in circumstances where it is probably not applicable. But I think one has to disregard that. I don't think there is a reason for concern when you have situations that do actually fall under the Genocide Convention, as long as one focuses on what really is meant by genocide and limits one's rhetoric to those situations. I don't see a problem. I myself am reluctant to refer to genocide as the crime of crimes, though you do see that in the literature, but that kind of characterization of genocide makes it seem as if you can never prove genocide because it's such a serious thing. Uh, so I think it's inappropriate uh, uh, to use that kind of of characterization, uh, not because it isn't accurate, but because it does lead people to think that uh, one can never actually prove that genocide is being committed.
In history, we had more cases where the crimes could constitute the genocide. When Turks killed at least 600,000 Armenians, or when Belgians killed around 10 million of Congolese. Is it possible to prosecute those crimes retroactively as genocide?
No, I mean, one can discuss those instances by reference to the wording of the Genocide Convention. But there cannot actually be any kind of legal action. The Genocide Convention came into force in 1951. So certainly nothing before then. And then, of course, you can only bring a case against a state that has given its consent to be the subject of a lawsuit. Um, so that would also be a limitation. Then, as far as prosecution of individual people, the International Criminal Court uh, came into existence with a treaty that dates from 1998, and then that treaty didn't come into force until 2002. So you can't prosecute for these historical situations that you mentioned.
Professor, bearing in mind your experience and expertise, everything that you know, that you saw, read, is there any intent in this specific case on the Israel side to commit crime of genocide in Gaza?
Mm. Well, um, the case for the proposition that South Africa does not have a strong case might be based on what the International Court of Justice has said in regard to the Balkans, where it found genocide for the mass killing at Srebrenica in 1995, but declined to find genocide for what has been referred to as the ethnic cleansing campaign in Bosnia in the years 1992 and 1993. However, the situation in Gaza is quite different because you do have this provision on inflicting conditions of life that are calculated to bring about destruction. the International Court of Justice did consider that clause of the Genocide Convention, but did not find it to have been violated. In Gaza, you have a strong case for the proposition that it is violated, because in Bosnia, regardless of what was being done to the people, the population did have the possibility of fleeing and going somewhere else where they could be safe. The population in Gaza had no such possibility. So it's more comparable to what occurred during the Second World War, when the Nazi government confined Jewish populations to certain areas. For example, in Warsaw in 1941, and deprived the population of the possibility of sustenance, deprived it of medical care, of food, and you had large-scale death as a result. That is precisely what was in the minds of the people who drafted the Genocide Convention. They referred specifically to these ghetto situations during the Second World War when they were drafting the provision about inflicting conditions of life that are calculated to lead to physical destruction. And that's precisely what they had in mind. So that differentiates the case as far as the International Court of Justice is concerned from what it had before it in the Balkans.
Since you mentioned the Balkans and the case of Srebrenica, one of the questions that was asked many times is how the crime in one municipality can be marked as genocide, or how it is possible that Serbs in Bosnia had the intent to commit genocide in Srebrenica, but didn't have the same intent or plan for the whole of Bosnia and Herzegovina.
Well, I mean, one could make the case that it was genocide in a broader area, but but as you say, the court limited itself to the Srebrenica situation. The Genocide Convention does not require that the actions are aimed at the entirety of a population group. That's evident from the wording of the Genocide Convention that says that your intent must be to destroy the group in whole or in part. So the court was able to take the Srebrenica situation and say this is a part of the group of Bosnian Muslims, Bosniaks, as they're referred to now, and that could nonetheless constitute genocide.
You mentioned that the Genocide Convention was adopted in 1951 with the idea that the Holocaust not be repeated, and if the similar crimes to Holocaust are repeated, to be defined by the law. Since that convention was adopted, we had 3 instances when genocide was confirmed by courts: Cambodia, Rwanda, and Srebrenica or Bosnia and Herzegovina. Now we have this in Gaza. What does this tell about us as a humankind when we are ready to commit this type of crime again and again?
That's a very broad question. But I mean, one could say that we collectively as humans have not learned the lessons of the past. And there are still situations where this kind of thing can result. But it often results in a circumstance where a particular population group feels itself to be under threat. That you could say is true of the Israelis, that they consider themselves to be under threat, whether from Hamas or more generally. So they regard what they are doing as necessary to defend themselves or to prevent future harm against themselves. One could apply that to the Serbian militias in the Balkans, who saw themselves as being under threats, having taken the stance they did against Germany during the war, and now the Croats collaborated with the Nazis, and so the Serbs see themselves as under threat. So, I mean, states don't, I think, just set out to commit genocide for no reason. They have reasons, you might say, for doing that. But then I think you can also look to the what might be called the minimum requirements for genocide. And that brings to mind the case that actually was filed by Serbia against the NATO countries in 1999 for genocide, for the bombings in Belgrade. And that was brought under the Genocide Convention by lawyers for Serbia because there is very limited jurisdiction in the International Court of Justice for acts constituting war crimes. So the only way to bring a legal action is to charge genocide, unfortunately. So that does incentivize states to do, I think, what you were referring to earlier, that is making allegations of genocide, even in circumstances where it is not clear that genocide is being committed. And in that case, the lawyers for Serbia focused on the fact that the bombs being dropped by NATO on Serbia had depleted uranium in the metal of the bombs, and that causes environmental harm and can lead to deaths of population. So the lawyers for Serbia, once they decided to make a suit for Serbia against NATO, had no choice but to focus on something like that. They didn't have a strong case for saying that the NATO countries were trying to kill the Serbs as a population group. So we do have some cases like that kind of put a basement, you might say, under allegations for genocide. Unfortunately, many states have filed reservations to the Genocide Convention, to the clause that allows for suits in the International Court of Justice. So that means it's really only quite rarely that there is even the possibility of suing a state for genocide. Israel has not filed a reservation to the clause about suits in the International Court of Justice, but many states have. The United States, for example, has filed a reservation to that clause, so that when Serbia tried to sue the United States in 1999, the court rejected the suit because the United States could not be sued. The case went ahead with regard to, I think, Belgium and the UK and other states that had not filed a reservation, but then ultimately dismissed the case on the grounds that the allegation about depleted uranium was not sufficiently strong under the Genocide Convention.
And at the end, what is your view on the situation that world powers use genocide convention, and international law when in their interest, and avoid them when it is not. The United States doesn't recognize the ICC from obvious reasons because it will spend lots of time in front of that court. Same thing with the Russian Federation. They don't recognize the ICC as well. So some could argue that justice is just reachable only for small countries. How can we make a more just world where the war crimes or genocidal intent apply to all, no matter how small or big you are?
Yeah, it's very difficult to bring any kind of legal action against a strong country, and there are examples of that in the International Court of Justice. That court ruled against the United States in a suit brought by Nicaragua in the 1980s. So the court ruled that the United States was legally at fault. But then there was a change in government in Nicaragua, and the United States worked out the matter with the new government. And so there was never any significant repercussions for the United States. And there was another case in which Paraguay sued the United States over the fact that the United States was not telling Paraguayan nationals who would be arrested in the United States that they had a right to contact the consulate of Paraguay. But Paraguay dropped the suit against the United States because the United States agreed to drop an investigation that it was doing against Paraguay for the pirating of VCH tapes. I mean, it's a completely different issue. But so the United States, as a strong country, had a way to pressure Paraguay to drop the suit. So I think this goes to prove your point that it is very difficult to sue a strong state, even if that strong state is not objecting to jurisdiction as a formal matter, but it will have ways of bringing pressure to bear on a weaker state.
Professor Quigley, thank you so much for your time, and thank you for talking to us. That was Professor John Quigley on rhetoric, intent, and how international courts interpret patterns of speech in time of war. This Sunday at 8 p.m. GMT, The Crime Not Meant to Be Hidden continues with forensic linguist Avni Ataive as we examine patterns of official speech and how language itself becomes evidence. If you are joining us for the first time, you can explore our archive, including the Gateway episode that lays the foundation for this season. Thank you for listening, Frontlines and Backrooms.